Just before we start, a couple things what our goals are for you today. I'm going to take the first part of this, and I'm going to be talking about helping you if you are contemplating instituting a business or complex litigation court, some steps that you will want to go through and at least consider as you build that court. Can I ask, is there anyone in here right now who is thinking about implementing one? Okay, so maybe you two will gain enough from that. Both judges, Judges Demby and Judge Moss, will talk about their programs in Philadelphia and Orange County, California. And as you know, as you heard, Judge Russo is standing on late notice, but I know he has a lot of expertise in this area as well. So that's kind of our format for today. Please, if you have a question at any time, stop us and ask the question. Other than that, get started. So where am I at here? Okay. So 7 steps, I call them 7 steps, and they're not written in any book. There's not any National Center publication. But this is just what I've come up with over the years of being involved in developing these types of courts. I will tell you this is broad enough to include not just business and complex courts, but also other specialty and problem-solving courts. So if you're thinking about that as well, you might want to consider some of these steps. So first of all, the first step, of course, and the most important one is defining your need, whatever that need may be. Now, I know that sounds simple, it sounds easy, but I think today a lot of us in the courts look at what's hot, what's out there, and want to bring it to our court and say this works. But as we know, our court cultures and our court procedures and processes differ from state to state, from jurisdiction to jurisdiction. So you need to do that, and you need to ask yourself, and the people who are brought together to consider this, you need to ask yourself, why do you need it? Why is it necessary? Identify who you believe will be the benefit. And I would caution you, if it's just the court, go back to work, because you're going to need partners in any types of these courts that we're setting up. So you need your partners to be able to benefit as well. And again, what are the outcomes you're seeking? Are you seeking to reduce the time to disposition? Are you seeking to reduce the cost of litigation? Many of our business courts today, and I know the one that we've put together in Maricopa County, which just started on July 1st, one of the outcomes we wanted to do is hopefully drive down the costs of litigation for our litigants, because we know from the studies that have been done recently that cost is a big issue today. So that for us is step 1. Step 2 is to establish that structure, or what I call a means for development. You've got to put the right people at the table. You've got to identify your strategic partners in the business community. It could be your Chamber of Commerce, and there are an array of other bodies and agencies, not just your legal partners, not just the bar. Of course, they're a very important part of it, but you need to be able to put that diverse team together to look at whatever the court is. I'm always an advocate of you don't have to create something new if something already exists out there. So one of the things I think you should do through this phase is take a look at other jurisdictions. For instance, in Maricopa, we looked at the Delaware Chancery Court. Right? By the way, Peter Kiefer is back here. He's our civil court administrator, so he knows a lot more about this program than I did. But we evaluated what they did. We took a look at courts in California. We took a look at courts in Pennsylvania, just to get ideas on what we wanted to do. This also is a stage where you take those objectives that were initially established when you sat down and said, why do we need this? But you need to clarify them and make sure, when you're establishing, make sure they're meeting the needs of your district. I know I'm an anal administrator, so I put in here conduct a SWOT analysis. And we know SWOT analysis, of course, is a strength, weakness, opportunity, and threat analysis. But I think you need to do that. You don't have to do it in the overall strategic planning sense, but you have to go through and identify what the strengths will be, where your weaknesses lie, what opportunities may be out there for you to partner with some agency you've never partnered with before, and what are the threats. And that threat, they could be from the bar itself. One of our objectives, as I said, was reducing the cost of litigation. And when we think about that, that sometimes flies in the face of what attorneys may want. So you have to be aware of that. Also, this is the body that I believe should develop and recommend policies and procedures that will be used, whether you have to change your rules in your local jurisdiction, whether you have to come up with new operating procedures and the like. But again, this is the group that I believe should be doing it. Next is to really take a look at three things. Once you've got through that process, you need to assess what impact those new rules, that new program, that new project are going to have on three specific things. Obviously to the court, and you've done that a little bit in phase 2, in the second step. But you really need to take a look at your employees and what changes these procedures and processes are going to bring to them. You know, we all have our stories about people doing the same thing all the time, every day. So if you change up a process or a procedure that requires personnel within your court to modify their duties, you need to identify it and train them on it. And most importantly, not most importantly, but we ran into this in our development in Maricopa. You know, we had to make some changes, some dynamic changes to our IT system to be able to track and identify the cases, to get the specific reports we were going to need for our evaluation. So that's step 4. And just very, very quickly, but I wanted to put this in because it is important. It has to be formalized, in my opinion. Just saying we're going to start this project, we've got ourselves together, we're going to start doing these new procedures internally, and we're not really going to engage our partners, I believe is a reason that you will fail on these programs. I think, and I call it the power of legitimacy, when the chief judge of the court, either you're in or the chief justice of the state that you're in, issues that order and formalizes the program, it certainly does make it easier to implement. Step 5. Very important step here, and you know, certainly you've got to notify, you've got to educate, and you got to train. You know, you use your public relations methods however you have them in your court, but through your bar association and through other means, through court newsletters, whatever you can use, but making sure all the partners who are involved in this know what's going to happen, as well as the stakeholders. And there is the issue of court staffing and court staff training, excuse me, that you need to pay attention to, because changes, you know, you can have a court, all the intentions are good, but if you don't properly train staff, you may have problems. Step 6. Again, this is one where you have to sit down and you have to be able to evaluate your project, your program, and how you're going to do that. We, again, in Maricopa we're using objective analysis. We're going to use the core tools, many of the core tool measures, to develop and to give the data feedback to our judges and our partners. But we're also developing subjective surveys, surveys for the attorney, surveys for the litigants. And I think, Paula, you're going to be involved in that process with us as we go forward, because we want to get some of that subjective data as well. So we're able to make an informed decision about whether this court is working or whether or not we need to make changes. And then lastly, I just said, is feedback. You know, and that's using your step 6 to determine what is working and what isn't, making those changes that are necessary with your partners, making informed decisions. And sometimes that informed decision may be, this court just isn't working and for us, and there may be reasons. And again, we should be in a position to state with data what's going on and why, and what are the recommendations for either modification or even cessation of the program. So that's taking you through the steps that I've identified. Before I go on, any questions for me? So let me now turn it over to Judge Denby from Philadelphia, talking about their program. And yes, I'm an anal court administrator. They don't have PowerPoints.
We don't need them.
Touché.
Okay, just to give you a little context, Philadelphia is a city of about 1.5 million people, and it anchors one end of the state that was famously described by Carville during one of the Clinton runs as Philadelphia and Pittsburgh and Alabama in the middle. And I bring that up because much of Pennsylvania is still quite rural. There are a number of counties that are very thinly populated, and so their needs and their court procedures are just very different from what happens or needs to happen in Philadelphia and in Pittsburgh. In Philadelphia, we've got 93 general jurisdiction judges. At any given time, we've usually got 33, 32, 34 of them sitting in civil trial division. When we began counting how many cases would fall within the purview of a Commerce Court, which is just about the very first thing you want to do if you're thinking of doing this, it came to about 600 cases a year. So we assigned 3 judges to it. We got our court started back in 1990, so it was one of the early ones. And the impetus to start it did not come primarily from within the courts. It came from the business community and from the commercial bar. They wanted judges who knew how to handle these cases, and they wanted some reasonable predictability in the outcome. And there was actually a move afoot to make a constitutional change and have these judges that were not regular common pleas judges, so we kind of beat them to the punch. As it turns out, the commercial bar has been a great supporter and has helped us a great deal as we've gone along. We decided, since this was an early iteration of business court, and since we did not have any good sense of how it would come out, to proceed with the blessing of the Supreme Court by way of a local rule of administration promulgated by our administrative judge of the civil side, which was just a lot easier than, we all know what happens when you try to change state rules. We all retire before these things get through. So, as I think I mentioned before, we assigned 3 judges, and a judge gets assigned to a case from the minute it's filed. Our filing is all electronic, and the filers generally identified as commercial or not. Sometimes they misidentify, sometimes the other side thinks they misidentified, or one of our court administrators does, and there's a motion practice for moving it in or out of the program if that needs to happen. Within a few weeks of the filing, they have a case management conference where we get an idea of the complexity of the case and set discovery deadlines, motion deadlines, and a trial date. Those can be moved, but at least they're looking at when the train is going to run them down. We have a small dedicated staff, a dedicated administrator to the program, and a staff of permanent attorneys in addition to our own law clerks. And that's very helpful because they've really, over time, become a real institutional memory, and they've got a good sense of how these cases have been handled in the past. And as I said, consistency as much as possible is a goal in handling these things, and they're terrific with that. They're also really good when you first move into the assignment and you haven't remembered anything about confessions of judgment since the day you took the bar exam or something like that. And the judges actively seek consensus. We'll chat back and forth among one another on issues that come up. We meet regularly, that kind of thing. Our criteria are for cases that are $50,000 and above, and a pretty wide range of business disputes. Some of them are straight contract disputes, some of them are internal shareholder partner disputes, some of them are business breakups. I used to think that doctor divorces were the worst, but I think lawyer divorces are far and away the worst. Insurance coverage, some of it in the context of construction cases, which it's amazing how many parties you get by the time everybody gets their spoon in. declaratory judgments in insurance, that kind of thing. As it happens, relatively few of these go to trial, and that's a very good thing. I've watched a couple of times as the jurors sit there in hard chairs and all these names and all these dollars go by once, and you really may as well just bring out your Ouija board and you get a better result. And the lawyers are aware of that. So one of the things that happens is a real active effort to get them solved. So as a part of that early case management conference, they are given a date a little further out when they know their left hand from their right to go to what we call a JPT, a judge pro tem, which is a very experienced lawyer or retired judge who tries to figure out the case and romance or threaten them into settlement. And at each step, we try to do that. Often the judges become actively involved in it. There's a lot of, as with every civil case, marriage on the courthouse steps kind of thing. But they are, despite the fact that you're not actually in court all that much, except for discovery disputes, they are very labor intensive. Because with these, unlike a lot of other civil cases, you really work pretty hard at narrowing these cases down. They're all filed with a sort of shotgun approach, and our job with preliminary objections, with summary judgment motions later, is to whittle it down so that you've got a clear something or other to grab onto and to try to get resolved. So that's a big part of what we're doing. What else? We also, because the judges who are in the court handle the case from the day it's filed until its eventual death, we go into discovery court really knowing the cases. So what we will try to do is prioritize what needs to be dealt with first. For instance, under our rules, you can't file a motion to throw a case out because the statute of limitations has passed until you get to a fairly far point in the litigation. Well, I've got one case where the guy's whining about what happened with his partners in 1974. So I kind of think that that's the big issue out there. So we will say, okay, that's it. Discovery is limited to this issue until. And sometimes in the construction disputes, you've got the owner, the general, the subs, the sub-subs, their payment bonds, their general coverage guys, their worker comp insurers, and you figure out where exactly, where's Waldo, and get the discovery on that done, and then the other issues tend to sort themselves out a little more easily. I guess I would say in looking into this, probably one of the biggest things you have to look at is the volume of cases. Is it worth taking a judge or judges out of your regular rotation and having them deal just with these cases? If they do go to trial, they tend to be on the lengthy side. They will take a lot of out-of-court time, so if you've got judges who are spending a lot of time in court, it's going to be hard for them to put the kind of effort into handling the pretrial motions that these cases demand. But it's really not worth doing if you don't have enough cases. And whether you do that on a statewide basis, which is what I was looking into, or whether you do it on a county basis, is going to depend on things like not only whether there's enough business in parts of your state to make that worthwhile, whether your lawyers and your litigants are going to be willing to travel to other parts of the state to deal with judges that they don't have a good feel for, and operate under local rules, which may be a little different from what they're used to in the big city. But those are things that that you can find. So I think that's just an overview of what we do.
My next. Hello, my name is Bob, and I'm an alcoholic. Oh, wait. I had the wrong notes from last night, and the 7 steps kind of threw me off there. But I got you all awake, didn't I? I'm from Orange County, California. There's an Orange County, Florida, I was reminded today, and I'm not from there. Orange County is the little county just south of Los Angeles. I tell people that's where the original Disneyland is, to kind of get your mind into where we are. Even though it's small geographically, it's a large population county. We have a little over 3.1 million people in Orange County, so it's bigger than about 21 of the states in terms of population. So we have a pretty active courthouse. We have 6 major courthouses in Orange County, and then we have some other buildings that we use. In California, as we so often do, we've taken a different approach than a straight business court. Rather than focus on case type, we focus on the characteristics of cases that need some special treatment. And we've done this since about the year 2000. I think that's Alan Slater's in the back. He used to be our CEO. He'll correct me on all this historic stuff. But it started in about 2000. Our Chief Justice of the California Supreme Court, then Ron George, came back from a meeting in New York and talked to the New York Chief Justice, and they had a business court plan in operation there, and he came back, and of course, what do? You create a committee to study it, and the committee came up with the idea of having complex courts instead of business courts, and I'll tell you what the difference is in just a minute. It started out as a pilot project back in around 1999, 2000. It's still a pilot project today. There was grant funding from the Judicial Council. In California, the courts are divided into counties, and every court gets an allocation for their budget. But this was extra money. This grant funding was extra money to finance these complex courts if you elected to try one. And therefore, a lot of courts that could handle it decided to do so. In terms of so let me tell you about how we're set up in Orange County. We have, I think there's about 24 general civil, unlimited civil courts in Orange County right now that handle all medical malpractice, personal injury, business cases, you name it. And they're all direct calendar courts. So every judge takes the case from the beginning. Every judge does all his own or her own law in motion. We don't have special masters that do that. In complex, we had 5 complex departments, but we now have 4. The types of cases that go into complex are varied, but they're all very big. For example, all class actions that are filed in Orange County will automatically be designated complex. In addition to class actions, other types of representative actions. In California, we have something called the Private Attorney General's Act that was really just enacted in 2004 or 5, I think. And what that code section does is, it used to be that for labor code violations, the labor commissioner would enforce labor code violations, but PAGA, the Private Attorney General's Act, deputizes private citizens to act as a private attorneys general. And that means they can bring a case on behalf of themselves and all other similarly situated individuals for labor code violations. And the bottom line is the state gets 25% of the recovery, and the private individual gets 3/4, or maybe, no, it's the other way around. Private individual gets 25%, but we're talking about millions upon millions of dollars sometimes, so it's a big type of case. But since it's a representative action, that goes to complex. In California, we have what are called JCCP cases. They're cases that the Judicial Council will farm out to a particular court. If, for example, if there's a medical device that's defective and a lot of lawsuits are filed over the same device, They'll coordinate all these cases into one big case, assign it to one county, and all those JCC, and they're huge cases, all those JCCP cases come to complex. We also have what are called CEQA actions, the California Environmental Quality Act. In California, to simplify it, every time a governmental agency approves a project or creates a project, they have to go through an environmental impact report. Many states do that, I suppose. And those cases are very complicated, take a lot of time. They all go to complex. Construction defect cases also have many, many parties, and construction defects cases of multiple homes, not a single home necessarily, but multiple home construction defect cases will go to complex. In addition to those categories of cases, any case with a large number of parties, there's no bright line, it varies. Or if it's very document intensive, a lot of exhibits, we're talking thousands of exhibits, that type of case. Or a case that'll take a long time to try. I think if the trial estimate's over like 21 days, it'll likely go to complex. And as Pam said, if the parties think it's complex and it didn't go to complex, they can make a motion to have it sent to complex. And the trial judge in general civil, if the case gets out of hand, gets too big, or the trial estimate expands, they can ask that it be transferred to complex. So there's a variety of ways that it gets there. When a complaint is filed in all of California, well, in Orange County, I'll just speak to that, we have a civil cover sheet that is filed along with the complaint. It's all done electronically, of course, now. And there you can check the type of case, and if it fits one of these categories, it'll automatically go to complex. In complex, the fees are much higher. It costs about $435, I think, to file a normal complaint in civil in Orange County. It's an extra $1,000 to file it in complex. And there's a cap on that for defendants up to 18, because you have multiple defendants usually. The fee is one time for the plaintiffs, and every defendant pays the extra $1,000, except when it reaches $18,000, we cut it off, and they don't pay beyond that, more than the normal filing fee. The bottom line is that the complex courts results in a great deal of revenue that comes in from this. Enough revenue, I think in 2014 our revenue was about $1.2 million from filing fees, and it cost us a little less than that, $900 and some thousand to fund the complex courts. The grant was about $850,000. We probably spent a little bit more because some of our staff will support complex in addition to the people that are funded by the grant, but our court has paid that. This year, the Judicial Council in its wisdom has stopped the grant funding for complex courts. I can tell you that our court at least has, it's been such a success locally that our court is going to fund it out of its own budget. So we're going to continue on with complex despite that. So what do we do differently with complex cases than we do with general civil cases? A simple way to say it is probably more of the same. The caseloads for the complex judges are much lower than for our general civil panel. They have about 600 to 650 cases per judge. In general civil, we have about 200 to 240 cases in complex. It's still a lot, and we'd like to have more, but that's the type of caseload. We have very frequent case management conferences or status conferences, whatever you would like to call it. Like Pam described, we have an initial case management conference. In my court, I have a standing order that there's no discovery, no motion practice until you've had your initial case management conference. We very often will limit discovery. For example, in class action cases, we only allow, some of us only allow discovery on class certification issues, because if you know anything about class actions, you have to get the class certified or the case dies. So that's kind of the central issue. We want to focus effort on that before we unleash the dogs of litigation to do class-wide type discovery. As a judge, what we're doing in managing these cases is we're often trying to find core legal issues that, if resolved, can make the case go away. So we spend a lot of time at these status conferences trying to isolate issues that might make or break the case. For example, alter ego might be a big issue if you have a defunct corporation and they're going after the stockholder of the corporation. And we can try that issue of alter ego separately, try it as an issue, and if, depending on the outcome, the case either goes forward or it often will die. So we're constantly looking for that kind of thing to make the case go away. As Pam described, our experience is the same. Very few of these big cases actually get tried to a jury. They're just almost too big to try to make 12 people with driver's licenses sit in a courtroom for 2 or 3 months. I mean, it's just almost impossible to do. The lawyers know that, the judges know that. So it's really a case of manipulating the litigation into a position where it can get resolved. The sooner the better. Facilities, we have, in complex, we have to have larger courtrooms because we have more lawyers. The audience section isn't much larger than our regular courtrooms, at least it isn't in mine, but we have 4 counsel tables in our courtrooms so we can accommodate more lawyers. We have a smart podium with a lawyer can plug his or her laptop into it and display what's on their laptop on our video equipment in the courtroom. They can do exhibits that way. We often have lawyers submit their exhibits in electronic format instead of paper. We're fortunate in Orange County to have all of our, we don't have paper files anymore. We have all electronic files. We have access really from Starbucks in Buenos Aires if you want to. You can access the court's files and see, the judges can too. We can see not just the pleadings, but all of the minutes and all that stuff that goes on in a lawsuit. So it's very, we're very tech savvy in Orange County, and we use that a lot. And you almost have to be there to have a complex court like this. Let's see, what else? Our courtrooms have, it used to be unique in that we had video evidence presentation equipment, you know, built-in Elmos and disc players and all that we can project on our LED screens in the courtroom. But now most of our civil departments have similar equipment. So and I know a lot of you have that already. But you almost have to have that kind of thing to accommodate cases like this. I talked to you about the revenues that we've generated. It's been a profit center if we were a private business. That's not the only reason to do it, but it does kind of pay for itself, I think. And the public that we serve, and we learn this through the lawyers, not so much the individual clients or the corporate clients, but the lawyers are very, very supportive of this. A whole bar has grown up that does complex litigation, and they're used to it, they're used to the way we do business, and they like it very much because they know that they're not subject to some of the rules that apply to the smaller cases. It's worked very well for us. That's about what I can tell you about California's system. It's going to go on. I don't think there's any plan for business courts in California, but we kind of do. We do the antitrust and trade regulation claims and securities claims or investment losses involving lots of parties. So we do a lot of the things that a business court would do, but not exclusively. Okay, thanks.
So what happens when you have 24 hours to prepare? Oh, I am not Judge Horn, but Judge Horn had a death in his family, so he wasn't able to join us. So if I could give you a perspective, but maybe I have some questions if I can ask you first. So first I'd say Ray calls it in Maricopa County anal. I call it obsessive compulsive disorder because it sounds good. Right? That's what I am. And if I had more than 24 hours, I'd have a PowerPoint presentation up there. Mine would have had little designs and fireworks and things going on.
Animation.
Animation, definitely. So here's what I would say. So if I could get just a feel, how many of you currently have a commercial or business litigation or are really truly looking to start one in your courts? Okay. Because I'm going to be, I don't want to be the negative, but I'm going to share with you the pitfall that I had in Cuyahoga County. So we're, 1.5 million population, and the state of Ohio, through our Supreme Court, had a pilot project with what we call a commercial docket, or the same as business litigation. And that pilot project was started with 5 counties throughout Ohio. And we were one of the 5 that piloted. And had success, but only the success that was limited within the pilot project. And our Chief Justice has chose 2 judges to be the pilot project judges. So then when it became an opportunity to vote it in, it was very contentious. I have a bench of 34 judges. How many of you are general jurisdictions? Okay. How many of you have judges that are elected? Okay. So then I'm going to share with you what I believe to be the Cuyahoga County pitfalls. Because what happened in my county is on a very narrow margin, we voted it in. And at that time, I was the designer of what we voted in. The pilot project was voted down. So the 34 judges, only 2 judges voted for it. You can guess who those 2 judges were. They were the pilot project judges. What happened is we then put in place a second proposal that met with the Supreme Court guidelines, and it passed very narrowly. And just recently, 2 months ago, that pilot project was voted down, or excuse me, the commercial docket we voted in was voted down because of these pitfalls. So I'll share those with you. And not any means of saying that it wasn't successful. But you have to look and say also what could creep up and rear its ugly head. So here, I wrote some down. For those of you who are savvy with your phones and iPhones, Superintendent Rule 49, I would have that on the screen right now. I don't. So you could go to the Ohio Supreme Court website, look at Superintendent Rule 49. It is defined very specifically of what a commercial docket court is. And if you have a commercial docket, you have to follow Superintendent Rule 49. So if you're looking for a model and you're looking for rules, go in and borrow that. Make a copy of Superintendent Rule 49. It'll guide you on how a case gets in general jurisdiction to a judge. So what happened? Why was it a pitfall for us? 1, judge shopping. What was happening in our court is that the lawyers knew who the judges were and knew that I want to avoid these 10 or 11 judges who are in the general jurisdiction because maybe they don't handle matters like I know these 2 judges are going to do. So they would code their case and file their case specifically to meet Superintendent Rule 49, so it came in as a commercial case. When I did an audit of our cases, 643 cases, a third of those cases were collection cases. They were business collection cases. Yes, they were business related, but man, they were not complex. But the lawyers knew I could get it in, I could get to these judges, and I know how my case is going to move. So that was one problem, is that the coding of the case was creating a judge shopping form for the lawyers. Elections. So if somebody is campaigning for an election and you're a general jurisdiction judge, what we saw for the 2 judges was a huge amount of plaintiff and defense lawyers on the civil side donating money to their campaign. So the 2 judges who were in the pilot project raised $150,000 to $225,000 compared to a judge who maybe raised $50,000 to $75,000. And we became aware of law firms and actually had one of our judges' wife is in a big firm litigation. And the emails that were going around between the law firms, hey, don't forget to go to Judge X's fundraiser tonight because, this is the judge we want to stay on the commercial docket. And even one comment that said, I'm so glad we only have to donate to 2 judges this year and not 9 because of the campaign, because all they did was business litigation. So there's a second pitfall and also some animosity that was built between our bench with the judges. And then what we were not doing, which sounds like the judges were doing on their dockets were, and as I think it was step 4, measuring success. You know, what was success for our court? And we weren't, when we jumped into the project, we weren't sure what success was. Was it moving the case quickly? Was it resolving it without a trial? Was it having the motions to compel immediately? Because those are all part of Superintendent Rule 49. What we then were able to determine is that, in fact, the commercial docket cases were taking longer on the docket than a normal case under the superintendent rules under the Supreme Court. So those were some of the pitfalls that happened in our court that created this animosity, and then the other judges said, forget it, we're going to vote this down, and we're not going to have it anymore. Now, those all began to rear their ugly head after we voted the docket in. And there was some hope that we'd get around that, and we were getting to that, and then there was an issue about an appointment of a judge, and that appointment not happening, and it became an issue with our bench, and then the docket died. So now those are just pitfalls. We did not have lower case numbers, so you weren't given a less of a docket. Because we were general jurisdiction, you got the same criminal cases and you got the same civil cases, you just had to follow a certain rule in order to keep the case. We do in our state have a complex litigation track, which gives us a longer period of time to try a case, and that's different than the commercial docket track. I will say this as the administrative judge for the 1.5 years, almost 2 years that I've been there. It was successful when you look at some of the statistics that you measure on how to handle a commercial docket. It did resolve a lot of issues earlier to get the parties in, the non-compete clauses, the restraining orders. Those things did happen faster, and there was a lot of positive to that, where there wasn't a lot of expenses being accumulated by the lawyers. Accessibility was definitely there. When you needed the judge, you got the judge. When you needed a hearing, you got the hearing. When you needed a ruling, you had the ruling, but the cases weren't moving any faster. So I'm not here to say that commercial litigation or commercial dockets or business litigation is bad. I just think in my court and having 34 judges, and the last thing with elections, it was being used in the election format for re-election. That I'm a commercial judge, and that, you know, I do this type of work, and it was used for re-election. It was also used as an attack to say against those other 7 judges that were up for election, well, Russo's not a commercial docket judge. His docket's small. He still has problem moving his cases, and he doesn't even have those complex cases on his docket. So it was kind of used as a negative for those other judges that were running for election as well. So I just give them to you not to say that there was anything bad, because I thought it was really a benefit, but these did rear themselves in our jurisdiction. So I'd leave that with you.
Can you imagine what the guy would have done if we'd have given him 2 weeks to prepare? Okay, our plan was to go for about 45 minutes and then give you the opportunity to ask anybody, any of us, questions on any issues or questions you may have about business and complex courts. So, anyone?
In Orange County, you said if you had multiple defendants, only 18 of them had to pay the fee. How do you pick the 18?
First come, first pay.
Okay, so it's first to file, or to bring it in.
Okay, thanks. Anyone else? Questions? Yes. You guys are going to play ping pong with me, aren't you? I need the
Somebody over here get a question real fast.
So each of you have spent time talking about civil matters. I'm not in the civil section, but I deal with more criminal cases. So can you use this? You had described a process of a case management hearing. Have you implemented that process on any type of criminal case scheduling?
Well, yes. I mean, again, Philadelphia is a pretty big jurisdiction, and of course we've got traffic court matters going their own way. So one thing, when you get elected judge, the first thing your friends and family ask are, can you fix the parking ticket?
What's the answer to that?
We're not that important, that's what I usually say. We in Philadelphia have a separate track for homicide cases. Our homicide judges hear only homicides. I think we've got 7 or 8 who do nothing but homicides. And as you might imagine, they're more intensive to manage. And then for our other cases, we do track them as they come in. They're either going to a room where it'll almost certainly be a non-jury, just by custom, non-jury, or else one that's pretty clearly going to be a jury case. And the lawyers can move it from one to the other, but we've got a pretty good track record of getting them sorted at the beginning, and makes it easier to move them according to management deadlines.
In Orange County, I've been pretty much civil the whole, I started out doing like misdemeanor criminal stuff for about a year, and then I've been civil ever since then. So I've never done the felony, and we're big enough to have you divide it up. You don't have a mixed calendar. But I do know we have long cause criminal calendars where big, long cases go to particular judges.
Yes.
Oh, you only made him go halfway.
Come on, come on.
I had a question in terms of the training, not so much for the judges, but for your non-judicial staff that are supporting the complex. If you could describe what kind of training that you have, or what kind of non-judicial support you have for these dockets.
Well, I'll start if you want. We have about the same courtroom staff, exactly the same as we do in general civil. Right now I have a clerk and a courtroom attendant. We used to have bailiffs in civil, but we stopped that because of budget concerns. We used to have our own court reporters, but that recently stopped. We now have pooling of court reporters. So I have 2 people, and it's different only in the sense that the cases, there are so many parties. But we have things, it's all electronic filing. Now we have a pilot project, electronic service. So if we have to send a notice out, it's done with a click instead of licking envelopes and putting stamps on them. So that capability makes it much easier. We do have a lot of people in the complex department to help you out when you first come over. Like I took my clerk from General Civil, came over with me to complex, and she got kind of on-the-job training doing that. You mentioned training. I really think there's a lack of training for the judges who are put into complex. There's virtually none. And they have classes all over the country, and certainly in California, on class actions, on CEQA matters, on all kinds of stuff, but you have to kind of seek it out and get it. There's no program to train a judge before they start that stuff. So I think it would be a good idea to have training for judges in particular.
I would agree with that. I found when I went into that assignment that it was about 3 months when I was living on the edge of panic.
Like,
you've done it when all of a sudden you can go through an insurance contract or a real estate contract and you're reading that fast instead of getting to the second paragraph and wanting to go out to lunch or burst into tears or something like that.
and the best example are class actions. If you've ever dealt with class actions, they're a different breed of cat than a regular civil case. For example, the judge has to, well, I mentioned certifying the class. The analysis in doing that is something foreign to what we normally do. But in class actions, at least in California, the judge has to approve settlements. Any civil person knows, hey, you want to settle your case? Great. But class actions, the judge is a fiduciary to the unrepresented class members and has to make sure that settlement's okay. So that's really a different kind of thing. Unless you've done them in your practice as a lawyer, you wouldn't have a clue as to how to do that.
Yeah.
Just as a follow-up question, is there, what do you do in terms of the judicial assignment of who ends up being assigned to the complex?
Well,
We try to get people who can count without taking their shoes off and using their toes, and we try to get people who can write an intelligible opinion at the end of cases, and we also look for people who have a history of managing cases intensively and really working to kill them off.
Yeah, in our court, as in probably many courts, we call it presiding judge, you may call it chief judge. The presiding judge has the authority over all assignments. That's really the only power the presiding judge has with respect to another judge. But in my case, the presiding judge came to my chambers, knocked on my door. Hi, Bob. you're going to be in complex next year. How about that? And I go, oh, okay. I mean, that's how it went. I didn't put in for it. I was just kind of tapped to do that. Imperfect, but that's how it goes.
Yes.
He said he was going to heckle me, so watch him.
Actually, this is a serious question.
Okay.
Judge Russo talked about judge shopping in his jurisdiction. In the other jurisdictions, particularly where you have self-identified complex cases, was there any cause for judge shopping, or was there any docket advantage to being on those dockets that caused them to misidentify?
Well, I of course, can only speak for my operation. As I said, our judges work actively to produce a coherent body of law. There's an awful lot of commercial law, business law that's still unwritten, uninterpreted, that kind of thing. So we have worked very consciously to be cohesive. Now, that's not to say one of us might be a little more short-tempered when it comes to stupid motions. Another one of us might be a little more lax about granting continuances, but there's not all that much difference. And because in addition to our own clerks, we also have this pool of clerks who have been doing commerce law for 10, 15 years, there's not really any particular reason for the judge shopping. Now, we have an advantage probably over what it sounds like the situation Cuyahoga County is in that we have retention elections every 10 years, but it's just an up-down. Nobody campaigns, nobody raises or spends any money except to go to the party dinner that we all go to in those years, and there's nobody who actually wants to hear from you. So you don't get that tension among the judges, and that can be real toxic to your bench.
Yeah, in Orange County, there's 4 complex judges, so everybody knows who they are, and they'll get one of those 4 judges. But we will screen the case. If I get a case on my calendar at the initial case management conference and I see it's a collection case, for example, well, it's not complex, and I'll send it back to General Civil. That's how we do that. So there's
And
no
how
way
often does that happen, though?
Not very often.
Because we did that in Fairfax, Virginia, with divorce cases. We had complex case, and what we didn't think about was that we said all the other divorce cases are going to be tried in 13 months, but complex cases will get 18. So these attorneys were putting in a complex where it was absolutely not complex just to get the extra 5 months before trial.
Well, the higher filing fee is a deterrent to that, too.
Yeah,
I mean, it costs
you have a
them
very
money
high
to
file.
do
Yeah,
that.
we didn't have that. It's the same filing
Yeah,
fee.
it's a deterrent to that kind of act. We just haven't seen that happening. And in terms of the judge shop, yeah. In terms of the political stuff, in Orange County, there aren't a lot of, we have not retention elections, but regular elections every 6 years, but no one ever gets challenged. It happens, but it's not very often, so.
Ours is probably a little more frequent, and that's because I think both the judges, the law clerks, both our own and the permanent law clerks, and the administrator of the program actively look for that kind of stuff. And also, when we send the case out for a lawyer or retired judge to try to get it settled, they report back to us, and they will say, there's a lot of smoke and mirrors here. There isn't $50,000 at issue, or this is something like a collection case. And we will then just order it back into the general trial pool.
I think we have time for one more question. Over here, sir.
Why is the dollar amount, the threshold, so low for Philadelphia? I mean, 50,000 is nothing.
It is pretty low. I don't know. We put that in there when we instituted the program. That was back in 1990. So in 2000. So it's getting a little long in the tooth there. And I guess nobody has actively campaigned to make it higher. As it works out with each judge managing intensively 200 cases. I think it wouldn't work if we had a smaller caseload, or it wouldn't be the most efficient use of time, so it's all right. But if I were starting from scratch, Iowa is in the middle of a pilot program to do it statewide, and their threshold is 200,000.
Okay, we want to thank you very much for your attention and your questions today. I hope we were able to answer them all and give you some tips on managing and creating business in complex courts. So thank you very much.